Hello, everybody.
Ms. Norden, can you hear me?
Yes, I can.
Excellent, thank you. We will go on the record in the matter 24 CF 60, State of Wisconsin versus Katie Mortensen. The state appears through Assistant District Attorney Kevin Schmidt in person. Ms. Mortensen appears in person in custody with counsel Renee Landgraf. We're set today in this matter for the sentencing portion of this case. Ms. Mortensen pled guilty on June 13th, 2024 to 3 counts of, to 1 count of burglary as of a building or a dwelling as a felony party to a crime, a 2nd count of burglary of a building as a party to a crime, and a 3rd count of burglary of a building or a dwelling and a felony as a party to a crime, and a 4th count of burglary in a building of a burglary of a building or a dwelling as a party to a crime. All other matters were dismissed and read in for purposes of sentencing. All in all, Ms. Mortensen was charged with 30 counts of criminal allegations and charges, most felonies, some as misdemeanors. None were convicted as a repeater. We're set today in the matter for the sentencing. The court ordered the pre-sentence investigation report. The court has reviewed that report, and other than some grammatical errors or spelling errors, the court did not specifically find any corrections or modifications that jumped out to the court with the court's knowledge and information. Mr. Schmidt, did you receive a copy of that report?
I did. I have no substantive corrections.
Ms. Landgraf, did you receive a copy of that report?
I did, Your Honor. My client and I reviewed it, and the additions and corrections that we have are listed in the defendant's sentencing memorandum, which was filed on the 27th in document 44 of the court file.
Thank you. Ms. Mortensen, you thoroughly went over the report, the PSI, with your attorney. Is that correct?
Yes, I did.
And did you have an opportunity to review or go over these corrections and modifications as listed in your attorney's response to the PSI and sentencing memorandum?
Yes, Your Honor.
The court has also reviewed the defendant's response to the PSI and sentencing memorandum as filed with the court and all of those accompanying documents. The court has also received and reviewed as late filings today, letters of support, character references on behalf of Ms. Mortensen. Mr. Schmidt, did you receive those copies and have you reviewed them?
I have, and I've reviewed them.
Excellent. All right. We have one victim who is going to be providing a victim impact statement to the court. I will ask that victim to come up here, have a seat at the black table, and you can either state your full name for the record and spell it, or simply just provide your initials if you wish.
My name is Jeff Washkuhn.
Can you spell your last name for the record?
WASHKUHN.
All right. Now you can provide your statement to the court.
How I was impacted was financially. I lost between $700 and $800 worth of stuff I had in the cabin. I'm on Social Security. It's going to take me a couple of years to get this stuff back, go buy it again. We lost personal stuff from my grandpa, other things from the cabin. Now there's 6 of us in that cabin, and I'm only listing the stuff that I lost. That doesn't include the other 5. This wasn't just a random act. It was planned out. We got a call from the sheriff's department on Sunday, and we went up to the cabin. The back door was busted in. There was piles of stuff all over the cabin. A half bowl or a half pot of chili on the stove they'd eaten there. Drank coffee there. We sealed the cabin up as best as we could. We couldn't get a door that day. We went back the next day with the door, and they'd been back and took all the piles of stuff that they had all through the cabin. The neighboring cabin, they had bagged all their stuff and put it out in the woods to come back and get later. This woman has no respect for the law or other people at all. I would like to see her get the max on what you can give her, what the courts can give her. She's been a repeater. Just no regard for anything or anybody. And I'd like to see her sentence. She'd get consecutive, not concurrent, and run this time separately from the other charges she had to deal with. I guess that's about all I got to say.
All right, thank you.
Yeah.
Mr. Schmidt, argument and sentencing recommendation, please. And for the record, the court has reviewed any and all of the victim impact statements that have been filed in the case as well.
Thank you. The PSI recommends a range of between 5 and 7.5 years initial confinement, 3 to 4 years extended supervision. They recommend it concurrent to all their cases. They're being very explicit. They want it run concurrent to another case they're clearly aware of, a Barron County possession with intent case where Ms. Mortensen recently got a sentence of 3 years initial confinement, 3 years extended supervision. So realistically, what that means is DOC gave a recommendation that if followed would, in terms of actual impact on Ms. Mortensen, result in between 2 and 4.5 more years initial confinement and between 0 and 1 more year extended supervision if the court did it concurrent. I don't know why they recommend concurrent. That's not what I'm going to be recommending. The Barron County case has really nothing to do with these burglaries. It's a possession with intent case in Barron County. When we seized their vehicle, when we searched the residence they were living at that they burglarized, there was nothing in there related to selling drugs. There's really no similarity in fact or time or circumstance with the Barron County case. And I'm not going to be doing a concurrent recommendation because I don't see why we would or how it's related at all. So I'm going to be making a consecutive recommendation. The consecutive recommendation I'm going to be making is going to be a recommendation of 2 years initial confinement, 3 years extended supervision on each burglary, concurrent to each other, consecutive to Barron. The reason I'm going to be making that recommendation, I'm going to start first by talking about where we have to start in every single sentencing, why probation is or is not appropriate. Probation makes no sense in this case because Ms. Mortensen was on probation when this happened. She had just been placed on probation for it out of Washburn County for the giving false name to avoid penalty and a theft case out of Washburn County. So the fact that this happened while on probation means we can't do probation again. It would depreciate the seriousness of the offense. Furthermore, when we look at the offender's account of why they think this happened, they trace it to their substance abuse. She complains that her current behavior is motivated by drug use. She complains that she didn't get sufficient help in the past from DOC in regards to treatment. So if the cause of the behavior is drugs and DOC has been inadequate to address it previously, it doesn't make sense to expect them to address it in the future. We follow that to its logical conclusion. If we take the defendant at their word that this was caused because I'm addicted to drugs, I can't beat my addiction on my own, and I didn't beat it with DOC, and that means treatment is necessary in a confined setting. That's where that logically has to go. It has to go to prison. So this was multiple burglaries. This was done with a co-defendant named Avery Weaver. In fact, one of the burglaries, the main residence they were living in, because they were living in one of the residences they burglarized, the police caught it. The owner went out and fixed things and started the process of cleaning up, and then they went back and burglarized the same one and went back inside. So that's a very aggravating factor. The fact it was multiple burglaries is aggravating. When we look at what they were doing, it was a little different than most other of these streak of burglaries we see. Typically, when we see people do a streak of burglaries in an area in our county, They go in, they steal the things that are the easiest to sell or fence or sell on Facebook, and then they disappear, they flee the area. These people were living in the area because part of it was motivated by poverty. That's both aggravating and mitigating, because it's somewhat mitigating because it's a cause that it's still criminal thinking, but it's a different type of criminal thinking than we're seeing before. It's aggravating because they didn't just go into the residences and say, no one will let us stay anywhere. We don't have any money. We don't have any shelter. We need to live. Let's be careful and just take the food or the gas that we need to live. They trashed these cabins. It caused a great deal of damage. When you look at the restitution supplement, the vast majority of that restitution is not reimbursing people for missing property. It's repairing damage. And that shows a level of indifference and lack of empathy with the victims as they were committing the crimes. They weren't minimizing their footprint, they were maximizing it. She and her partner fled from police in a high-speed chase. When they were caught, police knew what their vehicle was because they had trail cams that they had set up and knew what the vehicle was. And when an officer saw it, that's when the high-speed chase began. Regardless of who was driving, once the vehicle was stopped, it was Miss Mortensen who fled from police. They had to do a manhunt where they had 2 canines and found her because of a tip from an employee at Voyager. So that again goes towards probation's not appropriate because this is a person, she was on probation for giving false name to avoid penalty. She was trying to avoid penalty by fleeing the vehicle after it stopped. Probation would not make sense here. Her criminal history does reflect that going back to, I think, 2017, she's had a drug problem, specifically methamphetamine. That's been something consistent over the time she's not been able to deal with on her own. It shows that she did get convicted of a misdemeanor theft either right before or during some of these burglaries. It's kind of a gray area with the timeline of when these happened, because these were cabins where people were not coming back every single day. That's how it was enabled to happen. So around that time, she didn't have like a distant theft conviction. She does have a past criminal trespass, which I have no knowledge if that was theft related, but it's kind of similar to a burglary in terms of it being at a residence you're not supposed to. So why am I recommending only 2 and 3 out instead of, the victim said they want the max. The max, the court could do 30 years initial confinement on this. She could go to prison until she's an old woman. The reason why is because we accomplished something here through her actions that we don't normally get to do in serious cases that PSIs. We accomplished celerity. We accomplished alacrity. The biggest predictor of curbing recidivism is not doing the biggest sentence possible. It's doing the sentence as fast as possible, as soon after the course of conduct as possible. This was a case where Miss Mortensen was arrested and a complaint was filed in March. We had the prelim in April. Also in April, without any offers from me or from the police, she started helping the police. She told them what they did. She started helping them find the stolen property. The very next hearing was the plea hearing. There was no dawdling with statuses where, well, we want to get letters of recommendation. We want to do treatment. We want to try to, get things down. The state offered 4 burglaries and they said, okay. And that's how we got here today. We got here through true acceptance of responsibility. She's really throwing herself on the court with how they handled this and how they're going fast with this, how they're accepting responsibility with this. I sort of had an epiphany moment during this case when I was reading the reports about her helping recover the stolen property. It occurred to me, I couldn't think of a single other burglary case where someone did that. And the reason why should be obvious. But it never occurred to me before. Admitting you know where the property is probably the biggest thing you could say to assure, against your interest, to show that you're guilty. Because it doesn't just show that you did the burglary. It shows that you had enough either executive decision-making in the burglary or trust by whoever did that you were allowed to know where the property was. and have some control or creative control or constructive control over the property after the burglary. That's why people don't do it. So the fact that she did that really shows to me, you know, a lot of these burglaries, there's the empathy you may have for the victim and the remorse and actually feeling bad for what you did. And there's the self-interest. In this case, we can see through her actions and what she did with the assistance and getting the property returned, the empathy overcame the self-interest, which we don't see a lot in these burglary streaks. Because the nature of these burglaries is you have to be pretty indifferent to other people's feelings and thoughts and whatnot to go into residences and steal stuff and risk encountering people. Ms. Mortensen says the two motivating factors for her and why she was involved in it was one, the drugs, and two, domestic violence by Avery Weaver. I don't have any way of proving whether or not Avery Weaver was doing domestic violence or not. I can't really say anything to that and that purpose. The drug addiction is not an explanation for it. There are plenty of people who suffer from substance abuse who don't. That's not a reasonable explanation for the behavior at all. So when I look at the totality of the things, the 2 years initial confinement, 3 years extended supervision, I think accomplishes the purposes of specific deterrence while also appreciating what I think is genuine remorse and the ability to actually have made the victims whole with their own property rather than money that they'd have to spend getting something similar, but not quite what I had before. That's something that really is of high value and of high merit. I think it accomplishes general deterrence objectives too, because it's significant enough to send the message to the community. You get prison for burglaries. That's an important message to send. A Burnett County resident is 3 times more likely to be a victim of a burglary than a Wisconsin resident on the whole. We need to address burglaries in our county and prisons the way to do it, through general deterrence. It accomplishes incapacitation as well to some degree, because the totality of it will be, you know, run consecutive to the Barron case. She's going to be in prison for 5 years. And then she'll be on extended supervision for 6 years after that. So there's a lot of time over her head if she doesn't curb things, if she doesn't take substance abuse treatment seriously. She doesn't sever ties with Avery Weaver for her to go back to prison for another up to 6 years. Because we know if DOC revokes on cases, they'll often revoke on all cases if it's a severe enough violation. So she could face all of that for a single violation on probation for both of them. That's the reason why I'm making the recommendation I am. Thank you.
Thank you. And before I begin, at the last hearing, we did have a stipulation to $13,137.29 in restitution. That's still the case here today, correct?
Yes, Your Honor.
And that is from you, Ms. Mortensen?
Yes, Your Honor.
All right.
Joint and several with Avery Weaver.
Correct.
Yeah.
Joint and several with Avery Weaver. All right. And so I'm going to ask first, Ms. Landgraf, for you to provide your argument and your sentencing recommendation. Again, I have read and reviewed the information you filed. If Ms. Mortensen is going to provide a statement, and I did read that she has a written statement, or at least she told the PSI author that, I'm going to advise that she do so slowly, enunciate your words. And I know that this is emotional, and I can see it's emotional on you, but it's very difficult for a court reporter to be able to understand if we're hearing with tears and those types of things. So I'm not saying don't cry. I'm not saying don't show emotion. Just be cognizant of that when you're providing your statement so that we can make sure that everything is heard and taken down, okay? And then Ms. Landgraf, if she is going to provide a statement, please make sure that the microphone is back towards her so that the visiting court reporter can adequately hear. Ms. Landgraf.
Thank you, Your Honor. I did put my recommendation and reasons why in the defense sentencing memorandum, so I don't want to take time to rehash all of that. But in sum, I am recommending 4 years initial confinement followed by 4 years extended supervision, but concurrent to the Barron County case. I completely understand the state's argument for consecutive time. And I really don't think that the defense and the state are too far off as far as how much time she should actually spend in prison. 4 years. With the state's recommendation, she would have initial confinement for 5 years. With the defense's recommendation, she would have initial confinement for 4 years. The reason we're asking for a longer initial confinement and it concurrent to Barron County is to ensure that she gets the programming in prison that she so desperately needs. And one of the main reasons why probation is not adequate in this case. She was sentenced to prison in Barron County. She had 88 days credit. So she has a little over 2.5 years to serve on that sentence. She cannot take advantage of substance abuse treatment if she has an open pending case. So she has another open pending case in Barron County that she hopes to resolve soon, but we don't know how long that's actually going to take. So until that is complete, and then she has to have enough time on her sentence remaining in order to actually go into the program and complete the program. I think the worst thing here would be to send her to prison and then she doesn't get the substance abuse program. This will be her first time ever going to prison. So I think it's necessary that she able to get that program. So I understand, and I understand that this court typically does run as sentences consecutive to other crimes, but given the treatment needs here and also that she is serving Barron County on a methamphetamine charge, and methamphetamine, I do believe, was the main driver of the.
Again, I want to interrupt simply because it's not just a methamphetamine charge. It was intent to deliver methamphetamine. It was a large amount of methamphetamine, if I'm recalling correctly, over 12 grams.
11.
Oh, well, okay, 11 grams. Still a lot of methamphetamine.
Correct. And she did cooperate with law enforcement over there that resulted in several other arrests. I believe that the case there, and I think the prosecutor made the argument that her intent to deliver was to fund her own addiction and not to make money. And I think that's pretty clear with how she was living when these incidences were occurring. She doesn't have a history of having large quantities or having any other dismissed and read in cases or even been arrested for possession with intent. So I do understand the concern of the court that it's possession with intent is the charge, but I think all the parties in that case, and I did watch that sentencing hearing by Zoom. I believe that she was self-funding, and I think that's probably why Judge Boyle gave her 3 and 3 instead of a much higher prison sentence, which is not uncommon in Barron County to have a very harsh prison sentence for possession with intent. But again, I do think the state's recommendation is reasonable, and I do think it's appropriate. It's very close to what the defense's recommendation is. I just want to ensure that she's going to be able to get the treatment that she needs, because that will not only help her and her family, but also the community.
All right, thank you. Ms. Mortensen, I'm now going to turn it over to you to provide any statement you wish to the court to let me know anything that you want me to know or to consider to inform the court of if you've heard anything stated either inaccurately or not as strongly as you wish by either the state or by your attorney. Do you wish to make a statement here today?
I just have an apology letter.
All right. And again, please make sure that you speak clearly into the microphone so that we can ensure that it's all taken down.
Okay. Okay. The people I victimized. I know I hurt you, and I can understand why it may be hard to forgive me. I want us to be okay with each other. I hope you can forgive me. In the meantime, I will pray for you and do my best to repair the damages I caused. With God's help, I will work to overcome my problems. If there's anything else I can do, please let me know.
All right, thank you. And before I begin with any type of sentencing, in your sentencing recommendation or memorandum, Ms. Landgraf, you did request that it be a different conjunction of sentences. I believe with one of the counts, was it count one of the counts you wanted the court to consider doing a probationary sentence with a withheld sentence with a recommendation or an order that she comply with or apply to the Burnett County Drug Court. She's not a Burnett County resident if the court is recalling correctly that she is a Washburn County resident, so that would not even be applicable.
Okay.
I just wanted you to be aware of that fact. Only Burnett County residents can be in Burnett County Court. Only Washburn County residents can be in Washburn County Drug Court. Only Barron County residents can be in Barron County Drug Court. All right. Anything further before I render sentence?
No, yeah.
I have thoroughly reviewed all of the information and all of the filings in the court within the court file. And I sometimes do this and show, see, I take notes on all of the things. I take notes, I write things, I put my own little reflections on what I'm reading and how I'm reading it. I don't make any determination of what I'm going to do until the actual sentencing date and time, because quite honestly, it can be swayed and it can be changed, because I did have a recommendation from Department of Corrections with the 5 years of initial confinement, 5 to 7, and 3 to 4 with extended supervision. A lot of times the state, unless it's capped at a certain amount or it provides a different recommendation, usually falls in line somewhere near a Department of Corrections recommendation, but sometimes they don't, as they did here today, argue for something completely different than what the Department of Corrections did recommend. And because quite honestly, there are factors that come out through attorneys and through their arguments that I don't get to hear or see, even if in this pre-sentence investigation report. And your attorney is a really good attorney, Ms. Mortensen. She's very prepared. She's very efficient at what she does. And as you can see, because from the start to the end, it's a very quick process, and that shows on your attorney, that shows on you and your willingness to help and cooperate. But she is also one of the few attorneys that really do a great job for sentencings, and more importantly, for serious sentencings with her sentencing memorandums and all of the information that she gathers and provides to the court, which things can change and things can be added in the arguments. That's why a court cannot make a decision as to what to do with regards to sentencing. We're dealing with very serious counts, burglaries, and it's a crime spree, so to speak. And it lasted from approximately November of 2023 until March of 2024, where numerous people were victimized. So it's quite serious. And Mr. Schmidt has stated this not only in this hearing, but in other hearings. And this is a fact that if you're a Burnett County resident or somewhere near there, you're aware of this fact that Burnett County is at a serious risk, if you live here, to be burglarized. We are a very high county with that regards, probably because we have so many cabins. This is a vacation retreat. This is where a lot of tourists come. And honestly, criminals think they can victimize and burglarize and get away with it because no one's here. And I don't know if that's why Burnett County was targeted in your criminal spree, in your crime spree, or what the reasoning was for hitting Burnett County. When I first looked at this case and looked at all of the charges, all of the burglaries, all of the additional bail jumps, and I calculated the potential that hangs over your head, you could have a sentence of 171 years of incarceration. And that's a mix between initial incarceration, actually serving that in the prison, and that extended supervision where you're on kind of like parole, but yet you can be sent back to prison. 171 years of incarceration hanging over your head. That is beyond a lifetime. That is 2 full lifetimes or more, depending on your genetics, your health, etc. From this deal and this agreement, and I understand the basis, and I'll get into some of that later in my decision. This deal was generated by the state, whereas you were offered to plead to 4 of these burglaries because you assisted, you helped, you showed the remorse and the empathy for the victims. But with this deal, the coverage hanging over your head was reduced from that 171 years down to 50. Still a lifetime of incarceration that can be hanging over your head. 30 years out of that 50 could be initial confinement. I am within all of my discretion to say, you know what, enough's enough. Deter everybody. Let's send everybody to prison who's going to burglarize more than 1, more than 2 places in Burnett County for the max. And it is well within my discretion to say, you know what, 30 years initial confinement, 20 years of extended supervision, and to have it done here today. To have each of the counts be consecutive, and to have it be consecutive to the Barron County case. That would be harsh. Not that, again, that it is not warranted or couldn't be warranted, but that would be harsh. Especially considering the fact that you have shown remorse. And as Mr. Schmidt has said, you may be the first defendant, at least in his practice. And he was a defense attorney, and now he's a prosecutor. But you are also the first defendant in my practice as a lawyer and as my sitting as a judge for almost 8 years to have done that, to have said, you know what, here is all of the stuff. We broke into all of these places. I want to help. I want to work. And you know what? I understand what I've done. That's true remorse. I don't know how many burglary sentencings I've had in the last month, both in Burnett County and the other counties that I sit on cases. But I can tell you that your remorse, your tears here that you're showing here today are real. I can tell real versus fake. I can tell remorse of, oh, poor me, I'm going to prison now, poor me, versus I feel bad for me, I feel bad for my family, I feel bad for my kids, and I feel bad for the harm I've caused and the victims I've created. I see true remorse. Mr. Schmidt is exactly correct and right, and your attorney didn't necessarily say that she agrees, but in her recommendation, you can see that she agrees. This is not and could not ever be a probation case. Because the court would have to look at first needing to determine if the public is needed to be protected from you from further criminal conduct. And right now you are in this place. You've had time to sit while you're incarcerated, to get clear-minded and to be clear thinking, to sit and say, oh my gosh, what the heck did I do? That was terrible and that is awful. However, you're still not yet in a place where you can be sober, drug-free, and that clear thinking and minded, where I can be assured that the public is protected. You need confinement, and the public needs you to be confined. Because if I look at your previous sentences, sentences for your convictions, and your previous CHIPS case, you did well and you did become sober, but you didn't utilize the treatment and the treatment services in the community. You did for here and there and a little bit to get your kids back and to do what you needed to do, but not enough to have it be fully instilled in in you for you to continue to take charge of your sobriety and take charge of your life. And I'm not saying that you can't do it, because I believe, especially seeing this remorse and seeing this personal reflection, that you can do it. You are in a place you want to do it. But right now, the community is not an option. And so that's where we get to, you need treatment. Only a correctional institution can provide right now. And yes, she does. You're shaking your head, no, sister, but yes, she does. I see cases every single day. These attorneys see cases every single day. She does. And she will. She's going to prison right now for Barron County case. And if I were to put you on probation, even to do it consecutive to the Barron County case, that would unduly depreciate the seriousness of this crime spree, of the actions that you have done, the conduct that you have engaged in, and your behavior. Because the court has to look not only at you, and if you have the ability to rehabilitate. I need to look at the fact of the victims, and I need to look at other things as it relates to that, such as I need to look at if there's any undesirable behavior patterns. This appears to be your first burglary spree, and whether or not it was facilitated or a factor was your substance abuse in addition to domestic violence. In the end, you had the choice to do that. You had the choice to do that. I know domestic violence very well. I practiced as a domestic violence attorney, representing domestic violence victims. I understand it completely. And I understand the stress you may have been under and the anxiety you may have had and the fear you may have had while involved in that relationship. And I do understand that sometimes people feel there's no way out. But when we look at the law and we look at violating the law and we look at the repercussions from that, it still comes down to your choice. Many domestic violence victims in similar situations are not, they don't make the choice to break into multiple people's homes and or cabins. And you did that time after time after time. And I understand your excuse that you've provided about the fact, and it came through in one of your character letters that you may have been told that it was well, first you said it was an uncle's cabin, one of them, and then you may have been told by Mr. Weaver that it was his friend's cabin. But something in your gut had to say this isn't true. If we have to take a hammer, a crowbar, something to break into those buildings, and we're actually taking things from them, that's not true. And so if you're telling yourself and you're trying to tell the world that you did believe that those cabins were friends of Mr. Weaver's and he had the permission to take those things, if you truly thought that, then you're lying to yourself. I don't believe you believed that. And you're shaking your head no. That's just an excuse. So we're here for the accountability factor. And as I said, you did admit and you are taking the responsibility and you're saying, you know what, judge, you know what, victims, I'm ready to be accountable. I understand you have 3 unbelievably beautiful children that are really, truly victims in this matter too. And I did read the letters that did request and did plea to the court to allow you to come home as soon as practically possible because your mom's raising them. She's not in good health. The court can't look at it like that. I can't say, okay, criminal defendant who has hurt and victimized many people, damaged a lot of properties, it's okay because you have kids and you have to raise them. I can't excuse this behavior and say just because you have kids and they need you because they do, that it's okay. They do need you, Miss Mortensen. And they need you to be sober. They need you to be present. They need you to engage. They need you to help them with their homework. They need you to help them learn to count and to learn the colors and their shapes. And as much as it's going to be difficult in prison to be a parent, it can still happen and you can still do it. And I've seen it. And I've seen relationships actually grow and prosper with parents in prison and children that get to visit by video or telephone and send the letters and do the things. Because if you're going to go to prison, and you are in Barron for sure, it's your decision and your choice how you're going to respond and react and what you're going to do from here on out. And I know that a lot of blame wants to be put on Mr. Weaver. He's probably he is the most culpable. He is the mastermind. But at every juncture, at every point, you had choice. We have domestic violence shelters all over, and in particular, I believe it's Shell Lake, they have one, or they have two. There's one in Milltown. There's a satellite office here in Siren. There's help. I don't think you are a bad person. I think you've done a lot of bad things. And now you're going to have more felonies on top of the other felony convictions that you have had. And you're going to have to carry that for the rest of your life. Burglaries are classified as a violent crime. And sometimes, or a lot of times, criminals don't think of that. They don't think that, they don't realize that they are. Because at each and every place that you broke into, there could have been someone there. There could have been someone who was triggered to go there. A death or substantial injury or anything in between could have occurred and could have happened. You were breaking into somebody's cabin, because I believe they were all cabins here. We're breaking into their sanctuary, their haven. And you took away more than just property. You took away more than just financial aspects with the damage that you've caused. You took away a sense of peace, a sense of tranquility. You instilled fear that someone will come back, that they'll never be safe, their stuff will never be protected, and that they have to constantly be vigilant and watch out. And that's another sad part here in these types of cases, because as much as I am to focus on you and rehabilitating, and you can heal and you can learn and you can take control of your life and you can never do this again, I can't give all of the peace back to the victims. I can't ever make them whole. Even if I had all of the money in restitution and I gave it all back and I gave all of their property back, I don't have that magic wand to go zippity-doo and they're better. And as we specifically heard by JW here today, that this is particularly hurting him because he's on Social Security and he's on a very fixed income and he's not going to be able to replace his property or provide his share of the money for the damages and all of this for this shared cabin. And so it hits victims harder than others in different ways. I really want to see you succeed, Ms. Mortensen, and I want to see you do so much better, because I think you can. Even though I did read in the PSI that when you were in high school, you were having issues and you were having problems. I'm going to tell you that I don't know, because I don't have your records. I don't have any tests or anything to let me know your intellectual level. But the way you have been portraying yourself from day one of the arrest until now, not at the time of the arrest, because you fled and you tried to flee and you were not being very cooperative, but from the date of the time that you were arrested, after there was that quiet settle down time until now, you have presented that you have a good understanding of life and that you are a smart individual and you can figure it out. And quite honestly, on the top of my head, I can't recall if you did get your HSED. You have goals of getting your HSED. I think that is definitely something you can accomplish. And I want to see you accomplish that. Because just in reading the letters that fully support you and in hearing you and through the PSI and through your statement and through your attorney, you want a better life and you want to provide that to your kids. And it sounds like the father hasn't been involved hardly at all to be able to do that. So in hearing all of the arguments here today and in reading all of the information that has been presented, now I'm going to tell you what your fate is. I do have to correct Ms. Landgraf, though. This court doesn't always do consecutive. There are times when concurrent, even when they're separate cases, separate crimes, separate counties, concurrent is the most appropriate. But here, it's not appropriate. Because we have separate cases, we have completely separate crimes, completely separate times, separate people, and separate counties. There is absolutely no similarity in the time or in the fact. And as Mr. Schmidt stated, there was no evidence presented or found at the scenes or on you to believe that there were similar methamphetamine intent kind of things. And again, I understand the argument with regards to the intent to deliver methamphetamine for the Barron County case. 11 grams of methamphetamine is a lot. And it is more difficult to get that amount and quantity unless you have a larger sum of money and you know the right dealer. And usually dealers that deal like that deal so others can deal, so they can make the money to support their habit. It is. Even though it could be an argument that you had that quantity for you and Mr. Avery, there's also the counter argument that you had it and you could sell it and you can make the money to support your habit. And that is a serious crime. I don't think these crimes have to define you. I think you can build yourself up and you can be better. But for this moment, this is about the punishment factor, because you do need to be punished. You were punished in Barron for that, and you're going to be punished here for this. With regards to these cases, I was kind of swinging back and forth in my head, various things to do throughout and what to do with regards to the Barron case, because they happen so closely. And I do know you will be sitting at least 3 years in initial confinement and 3 years of extended supervision for that case. So and I was considering or thinking about having consecutive sentences for each of these counts, or for some of these counts together, because again, different days, different times, different victims, even though it may have been one spree of crime. But it doesn't just affect the victims all at once, because each of them were affected differently at different times. And each time you had the ability to stop and to think, or to tell, to run to law enforcement and to tell. But you didn't do that. I do want to see you get the substance abuse treatment if you wish in prison. Or quite honestly, I'd love to see you do the challenge incarceration program, because that is my favorite. And you need to have at least 36 months remaining on your sentence to be able to get into those programs. And even though you will be sitting time in Barron, for Barron's case, you would still be able to engage in programming, just not the programming to be released early. Because again, there needs to be that punishment component. So with regards to 24 CF 60, counts 1, 3, 5, and 9. What the court is going to do is I am going to sentence you to 3 years of initial confinement, 3 years of extended supervision, and again, that's consecutive to Barron County case. That gives you an opportunity to sit your Barron County matters and then be immediately eligible to engage in programming to have an early release. You will be eligible for substance abuse programming as well as challenge incarceration programming. This is consecutive, so you get 0 days of jail credit for this sentence.
Oh, Judge,
But she's not on probation. She wasn't on revoked or anything. How much jail credit does she
I don't
get?
know about that, but she's been in our jail on the cash bond for 181 days.
But when was she sentenced in Barron?
August 2nd.
I don't think they use that credit. Because their credit was
No,
way
they
lower
don't use
than
that
us.
credit, but she doesn't get credit from August 2nd on.
Correct.
Oh,
Correct. She was on probation during this incident and she is being revoked, but she has not been sentenced on those yet. So she has not received credit. So I believe that she would get 151 days credit. I did put that in my memorandum too, from the day she was on a cash bond until the day before sentencing in Barron County.
So you said 151 days?
That's what I calculated.
I'll put 151 days of credit. This is also going to be consecutive to any other sentence that you shall receive. Because again, you were on probation. You literally got on probation on December 5th, 2023. And then you went out and engaged in the first offense on December 24th, 2023, and followed thereafter. If I said February, no, it was November. The first one I believe was in November. And then you were placed on probation on December 5th. And then December 24th, you broke in and did stuff again and victimized. So it needs to be consecutive to any and all sentences, whether or not your probation revocation is concurrent with the Barron. I'll leave that to them. But this sentence is consecutive to all other sentences. On extended supervision, no use or possession of any illegal drugs, substances, or paraphernalia, no alcohol, no contact with Avery Weaver. I'm ordering that you participate and cooperate with the state in Avery Weaver's case. That you have no contact with anyone on any felony extended supervision or probation unless approved by your agent. No casinos, no establishments that have the primary purpose for the sale or the service of alcohol. You need me to go slower, I'm sorry. Gainful employment. Get your HSED or equivalent. And gainful employment would be gainful employment or continued education. A parenting class. Mental health evaluation and follow through focused on trauma and domestic violence related matters. The Thinking for Change or Breaking Barriers program while incarcerated. No contact with victims, their residences, or their cabins. I'm ordering you to provide your DNA. I don't believe that these are crimes that you would be able to get your DNA expunged, but if you wish to request that, you can write a letter to the Department of Justice. It's their discretion on whether or not they do so. $518 in fines and fees per felony count. $13,137.29 in restitution, joint and severally liable with Avery Weaver. No use or possession of a firearm for life, no voting in any election until your civil rights are restored. You have 20 days to appeal. Should you fail to appeal within 20 days, you do lose that right. If you fail to pay your restitution or your court costs and fees, the court will enter a civil judgment against you. You're always going to owe it, and you could sit up to 6 months in jail per count. Concurrent on the counts, consecutive to all other sentences. Mr. Schmidt, what is the state or what is the court forgetting?
Nothing for me.
Ms. Landgraf.
I don't believe there's anything missing.
Ms. Mortensen, I see a lot of people in front of me. I do, and the state sees a lot of people in their cases as well. It's very true that when I say, as well as Mr. Schmidt has said, we don't see many people who truly have remorse and who have empathy for the victims that they have caused. I do think that you are a good person. I think you have a good heart. I think you went down the wrong path with the wrong people. And I think somebody else, either your mother or somebody else in the PSI, did state that. And I do understand your trauma, and I'll tell you that what happened to you when you were a child. And that's specifically why one of the reasons, along with the domestic violence, that I ordered that mental health assessment focused on trauma. Because I think you have a lot of things you have to work through and a lot of things you have to heal. And what happened to you is not your fault. But how you conduct yourself and how you create your life is your fault and is your choice. And so I think you want to do better, and I can see that you want to do better, and I truly hope you do. Okay?
Okay.
All right. Anything further?
No.
All right, then we are adjourned. Thank you.
Be safe, be well, Sleep sweet and much love.